My name is Victoria Wilson and I'm an in-house solicitor working at Medical Defence Shield, and I've been a defence healthcare lawyer for 30 years. Today I'm going to give you a snapshot of some of the preliminary matters with a view to later expanding on some of the topics relevant to inquests. So the starting point is, what is an inquest? An inquest is an inquisitorial hearing, not an adversarial hearing, so it stands apart from other types of court hearings like civil and criminal trials. Inquest hearings are governed by a strict set of rules and regulations which are enshrined in the Coroners and Justice Act 2009, supplemented by some guidance documents accessible on the Chief Coroner's website. The rules say that a senior coroner who is made aware that the body of a deceased person is within that coroner's area must, as soon as practicable, conduct an investigation into the person's death if the coroner has reason to suspect that either the deceased died a violent or unnatural death, or the cause of death is unknown, or the deceased died while in custody or otherwise in state detention. The coroner has a broad jurisdiction in investigating a death. It is the coroner's responsibility to determine the scope of the inquest. Scope refers to the ambit, boundaries, parameters, and extent of the investigation and inquest. The scope of the investigation and inquest comprises those lines of inquiry or topics which the coroner considers to be relevant to answering the four crucial questions, which are who died, when they died, where they died, and how did they come by their death. During the early stages of the inquest process, the coroner will identify the evidence needed to properly investigate the death. This is where you might come in. If a patient has died in unexplained circumstances, then the coroner may well ask for a statement from the doctor involved, as well as gathering the medical records and any patient safety investigation report. Importantly, as a doctor, you have a duty to cooperate and to assist the coroner. This can be daunting, but it is a straightforward duty expected by the GMC. Where we come in is that we can assist you with preparing a statement, discussing your position in the inquest, and helping you to prepare for the hearing if you are to be called to give evidence. In terms of statement preparation, we are vastly experienced in advising doctors on writing statements for the coroner. You would have two lines of support from us, namely a medical advisor to guide and opine on the clinical issues, and a lawyer to advise on the legal aspects. In our experience, we have found that doctors benefit greatly from seeking our input. So if you receive a request for a statement, then don't delay in contacting us. We will be only too pleased to help. Once a statement has been submitted and the coroner has completed their investigation, the coroner then decides who is to be called to give evidence at the hearing. As a doctor, there are three ways you could be called to give evidence. First, you could have what is called interest person status, which is a statutory matter. Under section 47(2)(f) of the Coroners and Justice Act, anyone who may by their act or omission have caused or contributed to the death of the deceased, or whose employee or agent may have done so, will be entitled to IP status. However, even though this sounds worrying, the rules go on to provide that there is no requirement for the act or omission to be a culpable one. It is the mere fact of the involvement in the death that triggers the right to be an interested person. Having IP status means that you can have legal representation at the inquest, and your lawyer can ask questions of the other parties if necessary, and they can also make legal submissions or arguments about the conclusion the coroner should reach once the evidence is concluded. The other way in which you might be called is as a trust hospital doctor. The trust would usually be given IP status, and then all the hospital's witnesses will be represented by the trust lawyers. The third way is as a witness of fact. This does not entitle you to legal representation, and it usually means that your role is straightforward and your evidence is more peripheral. Another aspect of our advice is to review whether we think you need interested person status and the consequent legal representation. We can then make the appropriate request on your behalf to the coroner. If you are a member and have a query regarding coroner's inquests, then please contact our team who will assist you further.